Good afternoon, everyone. If you could please take your seats, we are going to get started with our keynote speaker. Today I have the privilege of introducing to you Senator Rand Paul. Dr. Paul is one of our nation's most consistent champions of liberty and defenders of democracy. In the Senate, he stands as a principled advocate against government overreach, defending the separation of powers, individual liberty, and the constitutional limits placed on our government. A physician by training, Dr. Paul brings to public service the same dedication he applied to medicine: careful diagnosis of the problems and practical, principled solutions. He never votes for an unbalanced budget. He returns millions from his Senate office to the Treasury. And he is known for holding government accountable through his annual reports on federal waste. He currently serves as the chairman of the Senate Committee on Homeland Security and Governmental Affairs, where he presses for transparency, accountability, and fidelity to the rule of law. A devoted husband, father, and grandfather, Dr. Paul lives his values daily and remains firmly grounded in his Christian faith and the community he and his family have built in Kentucky. He is also the author of several books, including Deception, The Great COVID Cover-Up, and The Case Against Socialism, reflecting his ongoing engagement with the great debates over liberty and governmental power. Please join me today in welcoming United States Senator Dr. Rand Paul.
Thank you. Thank you. Thank you, Mary Beth. That was great. When I hear the introduction, which I've heard a few times saying he likes to diagnose the nation's ills and problems, I was like, I'm always reminded of the Groucho Marx comment about the art of politics. He said, the art of politics is looking for problems everywhere, finding them, misdiagnosing them, and then applying the wrong solution. And if you've been to Washington, that is sort of the story of things, which is why the general proverb is, if it can be done by the private sector, we ought to leave it in the private sector. Government's just not very good at anything. People ask me, does that mean the people in government are stupid? And I say, well, not necessarily, but it's a debatable question. It's really about incentives. Why is the marketplace so good? Why is capitalism so successful? Because of signals and rewards, incentives. You know, the government doesn't have any of those. I mean, you could do the wrong thing for 50 years and still be employed in government. There was this one guy who was the assistant to the EPA, this is a few years ago, and we had a government shutdown. And during a shutdown, everybody's asked, if you're head of the EPA or the IRS, you're asked to make a list. Who's essential and who's unessential? The unessential people, it's great. You go home and you don't come in during the shutdown, but you're still going to get paid. And they all know this, and so it's a big racket. They love a shutdown. Everybody loves a shutdown. So anyway, they did this, and the IRS turned their list in, and they said 95% unessential. EPA turned their list in, 95% unessential. I was like, wow, maybe we could just get rid of 95% of these people. But when they were doing this, some guy popped up on the radar, and they started looking at his timesheets and trying to figure out whether he was essential or unessential. And he was like the second ranking guy at the EPA, and they looked and he hadn't been to work in 6 months. And they were like, what's the deal here? How can you not come for 6 months? And they talked to his boss, and his boss said, well, you know, he works for the EPA and the CIA. It's like, really? What a combo. I've never really heard of that. The EPA and the CIA. And he'd been doing this for like 10 years. He'd show up about 6 months of the year. When he felt like it, he'd come to the office, and he'd risen to the top ranks. And somebody during the shutdown, though, did this extraordinary thing. They said, well, why don't we just call over to the CIA and see how good a job he's doing over there? So they called the CIA, and they said, who? The guy for a decade had been taking 6 months of the year off, saying he worked at the CIA, and no one had ever bothered to call. And they did try to get some money out of him. I think he lost in court. It was like a $1.8 million judgment just from his salary over time. But government's not very good at things. And so one of the questions I love, and it's what's great about being a doctor coming to talk to a bunch of lawyers, is see, I got to pretend like I know stuff about the law. But I love the books of Randy Barnett, and I love the sort of the question, and I'll do this sometimes at Heritage. I'll ask, are you for judicial restraint or are you for judicial activism? And I'm not going to make you do that. But I love to have the young people do it. And of course, at Heritage, everybody says they're conservatives are for judicial restraint, right? You shouldn't be for judicial activism. But it leads to a great discussion. And Bernstein did this with Lochner Revisited, and then Randy Barnett's done this as well. How do you come down on Lochner? And the interesting thing about Lochner is that if you'll ask me, and then you'll ask Mike Lee, and then you'll ask Ted Cruz where you are, we're all pretty conservative, limited government people. But the more libertarians will be more for Lochner, and the more traditional conservatives are divided out and think Lochner's an overreach or a federal activism. I think sometimes it's in the eye of the beholder. It depends on what issue we're talking about, whether we're activist or for restraint. But I do think that there is a problem with the idea of the presumption of constitutionality. And that's the way Randy Barnett puts it. So does Andrew Napolitano in his books. He talks about the presumption of constitutionality versus the presumption of liberty. You can think about it a little bit in the terms of even like Chevron deference. So when we had vague statutes and there were administrative rules that have been created for several decades, including with initial support from Scalia, they would say, well, if it's vague, tie goes to the government. Sort of the idea that the presumption was, well, we'll just side with the government. The presumption is not liberty, the presumption is constitutionality, or that the government is right, and that went on for decades. And I think it's been a big step forward that the majority of court has rejected Chevron, and that they now believe in a little more, at least the presumption of liberty with regard to the administrative state. But I don't think we've gone far enough. And I was in the White House a month or two ago, maybe 3 or 4 months ago, for Robert Kennedy's swearing in. And Justice Gorsuch came in to do the swearing in. And how often do you get a Supreme Court justice where you can either needle them, give them a hard time, or try to have a discussion with them? And so I did. I said, you're my favorite justice. I love almost all of what you do, except for, man, did you screw up the TikTok decision? And he had a sense of humor. And my point was this, though. In the TikTok decision, they basically said it wasn't going to be strict scrutiny over the First Amendment. They made that decision. I think that's somewhat arbitrary. They said it wasn't really over content. This is a national security. I think they just sort of punted on the First Amendment and said it's a national security issue. But my next question is, if it's a national security issue and you think the Chinese are taking data, shouldn't somebody in some court somewhere present data that they're stealing the data? Not that they can, but that they are. But ultimately, Gorsuch's response was this. His response was, well, we defer to Congress. And that is sort of part of the law. I think it's in Hammond, Turner, I can't remember what. How do they all remember all these cases? But anyway, there is precedent that basically says that you can respect Congress's ability and predictive aptitude, and you just have to do that. The court's not supposed to get in the business of it. But really, you ended up having a decision where 170 million people are deprived of their form of expressing themselves. And they say, well, it didn't go after their content. We just care that it might go to China. But nobody presented any evidence that somebody is taking the data. And you might ask yourself, I wonder if I go on and make a YouTube, whether any of that information is scraped and given to anybody, or if I go on Facebook or Twitter or any of these places, are any of them scraping my data? They're all scraping your data. Now, we have an adversarial relationship with China, so we're more upset about it, but I don't know that it's any different, really. Also, there was no proof presented they were doing it. But I guess my point is this, is that I think the First Amendment's pretty important, and we ought to decide things on their constitutionality. I think they punted and decided this more on national security. And so when we look at things and you move forward from TikTok, the next big case, there are probably other things, this is just what occupies my time, would be the tariff case. So you've gone through a local court. They've said that the IEEPA, which is a sanctions law, doesn't say anything about trade and confers no power on tariffs. The local trade court, which is, I guess, like a federal district court, decided that he didn't have the power. It's gone to the appellate court, and then the next step is the Supreme Court. And I guess what I don't like about it is that we have this attitude, I think it's from Ashwander and Brandeis, list all these things for why you shouldn't decide on the constitutionality of things. It's like we try our best at the Supreme Court level not to address the constitutionality of things. But to my mind, it's a pretty clear sort of idea, and it's a big idea, not just a minor one, that the Constitution said taxes will originate in the House of Representatives. You have a case, you have aggrieved parties, and it's been presented before you. There are two arguments against the presidential emergency power here. One, the statute, that IEPA doesn't give the president statutory power, but there's also this constitutional power. And we end up bad government, and government stretching the point and not obeying the Constitution on tax authority will go on if the court doesn't address it. But with sort of a propensity to think Ashwander is a fixed thing, and we're going to stick with that, I predict what they'll do is they'll say, I think they're still going to rule against the president on this. They're going to say that I believe that the statutory power in IEPA doesn't give him power to address tariffs, but I think they'll probably punt on the constitutionality of it. I would go the opposite direction. It's just my opinion that really we should decide things on the constitutionality of it. So I think TikTok punted on the First Amendment, didn't give it strict scrutiny, and just said, oh, well, whatever, to 170 million people, because, wow, the Chinese, whatever, instead of really addressing or proving or looking at evidence and just saying we're just not going to give this the strict scrutiny that it deserves. So I'm not sure if I'm really good friends with Gorsuch, but that was my only really encounter, and I thought it'd be very interesting. Some of you don't look that interested, but I'll tell you that my only other really great encounter was with Scalia, and it probably wasn't that great either, but Scalia's wife and my wife were in an international club together, so we went, and I see him bellying up to the shrimp cocktail, so of course I want to talk about, does the Constitution confer a right to privacy or not? And I knew his answer, and I'm more on the libertarian side of this. Madison wrote that the powers of the government are few and well-defined, but I think the opposite is for rights. The rights are many and not necessarily defined. And Randy Barnett makes this case in the Ninth Amendment. He says that basically in the Ninth Amendment, they were worried about listing the rights at all because they said, well, if we list the rights, people will say that's all of them. And so some didn't want a Bill of Rights at all because they said that would limit. And so Randy Barnett's point and others' point is what they concluded was they'd put the Ninth Amendment in there and say, well, those rights not listed are not to be disparaged. So I'm a huge believer in the right to privacy. Absolutely have it. I think you've got thousands of rights. I think that the reason it got confused in conservative circles is that you got all that penumbra stuff about deciding, the Roe case, and conservatives said, well, we're not going to be for making up rights and creating rights, and that's an activist kind of role. I think Roe could have still been decided that way in a different fashion, but I do think you do have a right to privacy. I think you have a right to thousands and thousands of things that are not defined in the Constitution. Scalia didn't really think so much, and he I think went on for food somewhere else after our conversation got a little bit started. But I find the questions like this very interesting. The idea of judicial restraint versus activism. And I became more interested in this after reading Randy Barnett, who I highly recommend. I hope he's hearing this, that I'm promoting his books or whatever. I should get a commission. But about the time I read his book, and this is the one about the presumption of liberty, I think is back in 2003, was closer to the time they were making the decision on Obamacare. And I think it really is worth rethinking who you are, what you are, as far as presumption of liberty, presumption of constitutionality, judicial restraint, judicial activism, because they decide the Obamacare case, essentially Roberts comes down and writes that if there's a way you can imagine this to be a tax, if there's a way you can imagine this to be constitutional, you must. And one, I think that's just lazy, and I think it came to the wrong conclusion. But I think the idea that we're just going to, have hands off and do things really is a lot of times not led to good outcomes. You can look at Plessy. Who's the hero now in our history? John Marshall Harlan. He would have been an activist. He would have overturned the statutes saying separate but equal or fine. I bet you nobody in here is for Plessy, right? We're all in agreement. but we're still divided somewhat on activism. So I'd have been for activism. I'd have been with him there. Most everybody's Kentucky, right? So you probably know the Berea College case. In the Berea College case, once again, we have a segregationist Supreme Court, and they make a decision, to uphold, to be judicially restrained. We don't want to get in the way of the state legislature that's made this wonderful decision that blacks and whites, and I'm being facetious in case someone takes that out of context, this decision that blacks and whites should not be integrated as they were already at Berea. So I think it isn't so simple, and there may be a way of defining it where we can make it more simple, but I think I would like to see a court more active if it's on the side of the Constitution. Brown versus the board, kind of judicial activism, but most of us, believe that it was correctly decided. So the thing is that we get to Obamacare, we go through a host of cases. You go through the beginning of the Great Depression. The first 5 years was an activist court, and the second 5 years was a complicit court. FDR was going to stack the court, and people kind of understandably got upset, as they were upset recently, most of us, with the idea of stacking the court again. But he finally got his way because people that died, moved on, or retired, and he finally got the court he wanted. But for the first 5 years, it was a judicially active court in defense of the Constitution. They ruled most of his stuff, which was unconstitutional, until it wasn't. And I agree with the first court. I agree with the first 5 years of the 1930s, not so much with the second 5 years of the 1930s. But I think it's an interesting debate, and hopefully will be provocative to some questions. And this is all to say, I just wish I could be a lawyer someday. No, that's not true. I like opining as outside, because then if anybody asks any too complicated legal questions, well, I say, I'm not really a lawyer. So, thank you very much for having me. So maybe somebody can enlighten me. Who wants to enlighten me on judicial restraint versus activism? Do you have any of these debates? I was under the understanding that Randy Barnett and others had sparked some of these debates in the Federalist Society nationwide. Anybody? Yes.
Well, I will say I was the invited speaker at the first meeting of the UK Federalists. And the introducer got up and said, well, we're in favor of judicial restraint, so Judge Boggs will tell us why judicial restraint is good. And I said, whoa, I didn't know that was the be-all and end-all, is that, as a judge or as lawyers, you try to follow the law, and sometimes the law says the judge gets to make a decision, and sometimes the judge should realize that he should be restrained, because that's what the law says. The good word, or possibly the weasel word, is judicial engagement.
Right.
Because the idea that you never act or that you do everything you want, I think, are both wrong. Judicial engagement says you engage with the text, the Constitution, the statute, and then you either act or don't act appropriately, but it certainly is something that's debated strenuously, but that's my short answer.
And I think also it gets to the way the courts are constructed, is that most people think at the district court level it should be mostly restrained, and you're applying the law and not creating the law. At the appellate level, there's a little more interpretation of what the law is or isn't, and then there ultimately is at the Supreme Court. But I guess the rub that rubs me the wrong way is you get all the way to the Supreme Court, and they look at Ashwander and say, well, Brandeis says we should try to decide this on a statutory, if we can come up with a statutory reason. But the problem with that is then you keep doing the wrong thing, because if we decide the tariff case on statute, not on the Constitution, people are going to keep letting presidents write taxes. So I think the idea of a president creating taxes is such an anathema and such a clear rejection of the Constitution. Somebody's got to come up with, we got to, I think, figure it out in a different way, where we say it's so important, the Constitution is so important, and this is so against the Constitution. Why don't we, in this case, actually use the Constitution and say it says taxes originate in the House? The other problem we have with separation of powers kind of issues is most of the time the court just punts or says you have no standing. So my father was part of a case back in the 80s, and they sued over a tax bill because the tax bill started in the House. Actually, I don't even know if it was a tax bill. It had a House number, HR 32. Went to the Senate, they took it all out, every bit of it, and then they wrote a tax bill and stuck it under an HR number. And the problem is how do you get standing? How do you get to be an aggrieved party? My father and about 30 congressmen or 80 congressmen said they were aggrieved because they were taking away their constitutional prerogative to do it, and the courts just wouldn't hear it. And so for the most part, the court doesn't hear these cases for when they don't want to. They just say you lack standing, is my opinion. But we don't get adjudication of these separation of powers issues. I think in this president, though, we've already had probably more cases, and we'll have more cases than we've ever had in the history of our country, because this president assumes powers all the time that he may or may not have. And so with regard to hiring and firing, the Tenure in Office Act and that kind of stuff, the Democrats will loudly say he's breaking the law, he's breaking the law, but he's won almost all of those. I mean, almoast every hiring and firing cases, and I'm with the court on that. I think the president should have wide latitude. If the president can't fire you, who can? I can't fire somebody at the EPA. It's an executive branch. You've got to let the president do that. So I'm completely with the court, but we're getting more clarity because the court's actually ruling on these things. And so I think that's a good thing. The Democrats became crafty in the way they put legislation together. When they did the Consumer Financial Protection Board, they put it forward and they said, it won't require any appropriations. We're going to take a percentage of the Fed profit. Well, that should be unconstitutional. They're taking the power of the purse. Your representatives are no longer going to vote on it. It's going to be on autopilot, get money forever. The court, I think, punted on that issue, or maybe that issue never came up. But when Trump fired the first head of the CFPB in the last term, that finally ripened, and in 2020, I think, was decided that he does have the right to fire the head of CFPB. So I think he's going to win most of those cases. And I think it's good maybe that he's pushing the envelope on some so we can get a definition of where it is. But I just wish the court would more often decide on constitutional grounds and less often punt to statutory.
As a senator, couldn't you create a statute that would give standing to decide these cases and require and just basically handcuff the judges to deciding these cases by giving people standing?
I think there is legislation to do that, and I'm pretty sure I've been supportive of that legislation. I don't know how the court would rule on that. Does anybody know of any example of trying to tell the court what standing is or can be, or how the court's reacted? I don't know how the court would react to that. But I think that is one strategy that has been tried, and it has never passed. Anybody else? Yes.
First of all, Senator, thank you for being with us today.
Sure.
Suppose you win, so you get the functional end of the administrative state. You get the Supreme Court knocking out the president's tariff power. How does your branch respond, and what does your branch end up doing with what will end up being a bit of a power or regulatory vacuum?
I think that's a good question because, many people, there was, I can't remember which justice this was, but somebody was complaining, it might have been Scalia, and they were complaining about this and that, and this and that, and it was a congressman. And he finally looked at him, he said, he had the power. And they said, what, you mean to impeach the president? He said, no, you have the power to defund any of these things. So basically, the branch that I'm in is impotent. Madison said we would check power by pitting ambition against ambition. I am in a body of our government that has no ambition. They have ambition for self-glorification, for all kinds of things to be on TV. They have no ambition to reclaim the power of the purse. We have every bit. We could defund anything we want, and we could stop it. And they don't do it. But we actually are doing backflips, and some of this is fear of the president, frankly. In both the House and the Senate, when he declares an emergency, and realize he's declared an emergency on 150 countries. Emergencies you would think would be like war or famine or some kind of urgency. He's declared emergency because he doesn't like the trade policy of 160 countries. To reverse a presidential emergency, there's a privileged vote. So Tim Kaine filed it, and I voted for it. I was one of 4 Republicans, all the Democrats. One irony is I've been leading reform for emergencies for 5 or 6 years or more, and when Biden was president, I had 24 Republicans on my bills. They've all melted away. And so they're against emergencies under Biden, but not emergencies under Trump. And that inconsistency and hypocrisy, I think, is awful. But they lack this sort of ambition to reclaim power. And I think that we could at any point. There's a privilege in the House for overturning emergencies. Do you know what they did there? Somebody filed it. They passed a rule, because rules can override a lot of things in the House. The rules are very important. They passed a rule that said that a day is no longer a day. It used to always be a joke that Congress could rule day as night or night as day. We have that power through majority vote. Now they can declare that a day is no longer a day. So it's supposed to ripen in 15 days. So it was filed and it will never ripen because there are no more days. They made days disappear, which is so awful, and, I don't know. I'm just really disappointed. But it gets, the last 2 days I've been working with Thomas Massey, because he's one person who's willing to stand up on principle regardless of who's president. So what are they doing? 3 billionaires from New York are going to spend $20 million trying to get rid of him. So whether you like him or not, he's a thorn in the side because he's an independent thinker and willing to stand up to either party, and they don't want that. If you get rid of him, or you get rid of him and me, you'll have almost nobody left on the Republican side who's willing to call something as it is, to call something the truth or not the truth. You don't have to always agree with me, but somebody's got to stand up for something that they believe in, which is the Constitution, which is greater than any one person. Yes.
So addressing your question about judicial restraint, I think that sometimes I agree with judicial restraint, but I think that the basic obligation of the courts is to restrain the government from encroaching on our constitutional rights, and that's what's being omitted. You've talked about the issue with the federal government and the Supreme Court, but something I'd like to see walked back is the encroachment of federalism, where the federal government has usurped the powers of the states and continues to do so on such a large scale. And an example would be even something like binding arbitration. I think it was 1925, Congress passed the Federal Arbitration Act, and it always just applied to federal procedural law. And then I think it was 60 years later in Southland versus Keating, they said that it applied to substantive state law, and that it preempted state law.
Right.
As Scalia, or I think it was O'Connor dissented, Scalia later dissented, but there the court wasn't hands-off, and it totally upended so many of our rights to get to the court on contracts. And I just want, to ask what your position is, or what your belief would be the best way to bring the dog back into the kennel and get it out of the state house.
Yeah, I think the history of the last 100 years has been a history of federal supremacy in everything. And so it's not something I support. How we reverse it is another question. You end up having most of the business interests in our country come to Washington and beg to have a federal law overturn a state law. And almost, I can tell you, I could probably name 20 different business associations in the last 5 or 10 years who came to Washington and said, we hate California, which is understandable. All right, I understand that. We hate their regulations, their economic ignoramuses, all true, but we can't trade. And so they say it's interrupting trade because of these. So we want a federal rule to make trade more regular. So there's an argument that that's sort of an interstate commerce thing, but they end up overturning so many federal law over state laws. So the preemption of state law has become so common and often advocated by Republicans and so-called conservatives to do this. I disagree with it, and I'm with you that more things should be decided at the state level, even criminal law, for goodness sakes. There should be almost no federal criminal law. Most of the federal crimes are wrong and shouldn't even be in the law. Almost every murder should be tried in the state. Look, I was friends with Charlie Kirk. I'm still mourning his loss. His killer should be punished. Utah's got laws on murder. There's no reason. The only reason to do it is because I'm in the federal government and I want to show you that I'm the federal government, we're going to do this. And really, almost all that stuff, and particularly criminal law, ought to be at the state level. If you look at most of the regulatory crimes, they're obscene, the things they will do to you and can do to you over moving dirt on your own land. You can go to prison for a couple years for moving dirt without the right permit. I'm opposed to almost all the criminal penalties that have been attached to federal laws.
Recently, just another example is new. I might love the policy with regard to immigration that was announced and somewhat being enacted. But in my court, I've had criminal defendants that were arrested on my warrant for state crimes, pending trial, and then ICE somehow takes them from the jail and deports them. And the citizens that elected me have a right to have their crimes adjudicated. And I'm trying to figure out what the best way to attack that is, because that's a constitutional violation of federalism. And there's no guarantee, even if they're deported, that the individual wouldn't get back into the country anyway.
Right.
Citizens aren't getting their
I think some of that's still going to be adjudicated too. I don't think we've completely decided because there's a lot of interaction between ICE and state and overlap between the two. So I think that hasn't been completely adjudicated where the courts are going to wind up on it. I'm trying to have time for one more question, or maybe I'm done. That was my last question. I am done. Thank you very much for having me.